Anyone can make a claim, anyone can blame somebody else, and it's our job to really figure it out what happened. Sometimes not getting the job that you think you should have is the best thing that could possibly happen to you. You read every deposition backwards and forwards 17 times. The preparation for it, I think, is worse than actually trying the case. Once you're on trial, all you need to know is, what am I doing tomorrow? Sometimes the trial is just part of the negotiation. And this isn't monopoly money. This is real dollars. It is an absolute combination of a poker game, a chess match, and a gunfight.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a high-stakes trial lawyer who leads the medical malpractice defense department at Rivkin Radler. He's the attorney clients turn to when their professional reputations are on the line, having served as National Coordinating Counsel for massive toxic tort claims and earning recognition for securing one of New York's top 10 defense verdicts. It's my pleasure to welcome Eric Strober to the podcast. Welcome, Eric, and thank you for being here.
Thank you, Aniket. Thank you for having me.
It's my pleasure. Eric, as you know, I love to start by asking each guest to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
I'm not much of a joke teller. So my factoid kind of dovetails into how I got started into this, which is my path did not start into this. I kind of fell into it through a bit of luck and family history, which dovetails into how I got started in this, which is in law school, I needed a job. And as it turned out, my grandfather, who was a captain in the New York City Police Department for about 20 plus years, when he retired, he went to work as an investigator for a well-known lawyer at the time by the name of Charlie Kramer. And anyone who knows the history of medical malpractice work in the New York area, and perhaps nationally, knows the firm of Kramer Dilloff. They basically invented the field of suing doctors back in the 1960s and 70s. And my grandfather was Charlie Kramer's trial prep guy, because all the big lawyers back then hired cops to serve subpoenas, interview witnesses, all the legwork that had to get done. So when I needed a job, my grandfather called up the office manager at Kramer Dilloff, and my name was still at least recognized. So I was able to get my little toe in the door with a summer job there and kind of took it from there. So, and also interestingly is my father, who's a doctor, around the same time that my grandfather was working there, he was finishing or just out of medical school. So he would help them review cases, with what he had been just learning at the time. So it was kind of a fortuitous, constellation of circumstances that landed me where I ended up.
That's fascinating. Yeah, normally I follow this up by asking, what your origin story is, but you've sort of already shared that, and it's fascinating too, Eric, that it's across multiple generations. So it started normally it's like one generation. So hey, my parents or my mom or my dad was here, but it's like you had your grandfather, and then your father. That's amazing.
And what was really kind of interesting early in my career, which now goes back 30 years, at that time in like the late 1990s, I would run across lawyers who had been practicing who knew my grandfather as like Charlie Kramer's guy. So I don't run across them anymore because they're long since retired, but early on in my career, my name rung some bells. So that was it was nice to hear that people knew my grandfather.
That's always a source of pride, I'm sure.
Yeah.
And there's a nuance here which I'd like to come to in a little bit. But so the law firm that your grandfather worked with, they were on the plaintiff side then?
Yes. That was the plaintiffs. That's the only time I've ever worked. Well, that and another summer job in law school. The only time I've ever been on the plaintiff side was doing that. And after law school, and they're still the premier plaintiff's law for medical malpractice firm in New York. And it's been run by Tommy Moore, who's nationally and famous, and his wife, Judy Livingston. And at the time, they were not hiring kids right out of law school. They figured there was, too many of their clients had millions of dollars and their lives depended on, so they were not really, they said, I had to go learn what I wanted to learn and needed to learn on the defense side and then come back to the plaintiff side. But I never felt the need to go back to the plaintiff side after starting my defense journey. So
fascinating. Yeah, so let's actually take it back to sort of where you were in law school. So where did you go to law school, and what was your journey after Kramer?
Okay, I went to Brooklyn Law School. After being in Syracuse for 4 years undergrad, I had enough of the weather of the snow belt. And here's another little interesting factoid. At the end of law school, I was on a path to become an assistant district attorney in Orange County, New York. And for a couple of different reasons, I had a job offer and it ended up falling through. So I was back to square one, and I ended up getting a job, and it took a little bit of time, a few months. I ended up in civil defense, having been kind of pushed off that prosecutor track. And it's kind of a lesson that I've learned and passed on, is like, sometimes not getting the job that you think you should have is the best thing that could possibly happen to you. If it's not meant to be, it's not meant to be. And that clearly was the case for me, where I'm not cut out to be a prosecutor. I'm more cut out to do what I'm doing. So I ended up in the right place regardless. And that was at like a 20 or so lawyer defense firm that was run by some very experienced, defense trial lawyers. One has gone on to a big career in, doing television commentary and such. And the other one who I worked for is a guy named Bruce Brady, who's now retiring, but one of the great med mal defense trial lawyers in the city for the last, 30 plus years. So I learned from some very good people at that stage of my career, the first couple of years.
That's great.
Yeah.
It sounds, Eric, like a lot of your work, and it's very important work, is centered around the New York City area. But there is an interesting angle, which is that earlier in your career you assisted Attorney Paul Callan in the successful civil case against O.J. Simpson, who was a coast away. So can you talk a little bit about your participation there and your lessons?
Sure. So at that first small firm, it was called Callan, Regan, Streich, Coster, and Brady, and Paul was one of the founders of the firm. And Paul had been a homicide prosecutor in Brooklyn for years before he did civil work. And apparently, unbeknownst to me at the time, a lawyer by the name of Kelly reached out to Paul, and he was second seating the estate of Nicole Brown Simpson, or Sharon Rufo, Ron Goldman's family, in the civil case against O.J. Simpson. And Paul called me down to his office one day. He's like, Eric, I think I got him an interesting case for you to work on. I'm like, lay it on me. He's like, we're going to help out the OJ civil case. And I was a first-year law student, lawyer at the time. I've been doing GL, general liability, but I guess I mean, not to give myself too much credit, I do kind of have a knack for this kind of stuff, and I guess I always did. So they recognized that, and Paul needed help. So we didn't have a lot to do. I never got to go to California. I got to sit in New York and write some pretrial motions that got filed on evidentiary matters and such. I didn't have a file. At the time, it was the biggest thing in the news in 1995 or 6. And my research materials consisted of whatever the New York Post printed the night before, and whatever scuttlebutt and rumors that were out there that we wanted to keep out of evidence. My job was to write a motion to keep that stuff out of evidence. And then it came time where it was time to leave that firm, and I had some pretty good writing samples to attach to my resume, because at the time this was like the biggest show on television. It wasn't the criminal trial of the century, but in civil circles it was still pretty big and everybody recognized it. So I I used that to make the next step in my career to a bigger, better spot.
That's great. Can you talk a little bit about the trajectory from that point on, from all those writing samples to where you are today?
Sure. So that came to the next big pivotal moment in my career. Sent out resumes, and I ended up getting an offer from, it was a firm called Parker Chapin, which was a big white shoe firm on 6th Avenue at the time that had a small medical malpractice civil defense group that was run by a lawyer by the name of Jesse Graham. And meeting Jesse and getting hired by Jesse and working under Jesse Graham was probably the most important thing that ever happened in my career. Jesse was the main trial guy for a big defense firm in New York that had existed for many, many years called Bauer and Gardner. They were the 800-pound gorilla of defense work in New York City, had hundreds of lawyers. They were like the monopoly, and they had broken up. Actually, when I was at Kramer Dilloff one summer, Bauer and Gardner dissolved. It was the summer of '94, and they fragmented into many, many different defense firms. And Jesse and his partner David brought a small group to a big white shoe firm, and I was able to join up with them then. And Jesse kind of took me under his wing, and he still to this day is one of the best defense lawyers to ever have done this job. So that was extraordinarily lucky for me that he was there and needed help, and he recognized that I was, a good person to train. So he did. And I started working on malpractice cases with him, and eventually I started second seating him on trials. So that's kind of how I learned, was under the wing of Jesse Graham.
That's fantastic. And so how long have you been with Rivkin Radler?
So I guess that brings me to the next pivotal point.
Yes.
But after about 2 years of being at Parker Chapin, that firm started teetering and needed to dissolve and sell itself to another firm. And they, I think, were not going to be able to sell themselves to another big white shoe firm with us, down in the trenches, med mal defense guys who were not earning $600 or $700 an hour at the time, which was a ton of money per hour. Now those guys are in the 4 digits by far. So it was time for us to take our group and move it to another firm. So we did, and we hooked up with Rivkin Radler, which was a good fit. It was a Long Island-based firm, and the other senior partner, David, lived on Long Island. Jesse was in the city, and a few other of us, we were in the New York City office and kind of splitting our time between. And it's been a great spot because of the atmosphere, the way the firm is run. And I've been here ever since. And, the only thing I can tell you, when I was up for limited partner, I was brought into an office. It's 2005, and asked by one of the senior partners, why do you want to be a partner, Rivkin Radler? And I hadn't thought about the answer at the time, but I just came up. I said, I like the work I do, and I like the people I do it with. And he's like, great answer. And I still feel that way. I'm in a little bit different position now because I'm the one kind of at the top of the hierarchy, at least in my group. And I still like the work I do and the people I do it with.
That's great. What a journey. That's fantastic. We'll come back to your role in the firm in a little bit, but I want to touch upon a little bit of the work that you actually did. So,
Sure.
In 2004, you obtained one of New York Law Journal's top 10 defense verdicts of the year. Can you talk a little bit about that case? What were some key milestones and so forth?
I don't want to give myself too much credit at all, because I think they picked that out as a top 10 defense verdict, not because of how hard it was to get a defense verdict in that case, but just because of how kind of absurd the case was. And it got some notoriety or some press attention. Briefly, it was in federal court, which was a new thing for trial. And it was one of my first medical malpractice trials. And it was for an insurance company who we were really not doing much work for anymore. So Jesse and my partner said, go try the case. So I'm like, all right. So I represented a psychiatrist who was part of a team at Mercy Medical Center in Queens. And way back when, a gentleman by the name of William Kanye came into JFK Airport looking very suspiciously like he was smuggling heroin. And he was. Every time he dozed off, they gave him Narcan and he woke back up again. And they x-rayed him at the airport and he had 51 bags of heroin in his GI tract.
Oh, man.
And they said, we got to take you to the hospital and you need a surgery or you're going to die because one's leaking. And he absolutely refused surgery. You're not, I was like, I've done this before basically, and I'll be okay. They're like, you're going to die if we don't do the surgery. So they had to call in my client, who was a psychiatrist, to override his refusal to consent. And she did. She said that he's not of sound mind at this time. He is lacking capacity. The surgeons all agreed. So the surgeons operated and saved his life. And he did 27 months in prison and was sent back to Ghana. And he sued. He sued the United States of America, which is how we ended up in federal court, and the surgeon and the hospital and the psychiatrist. In federal court, it's very interesting. We picked a jury and did all the opening arguments in 2 hours. It just so happened that across the hallway, one of the Gambino gangsters was on trial. So the New York Post and the Daily News had reporters in the hallway. So they got whiff of like the drug mule who had a malpractice case against the United States. And they started kind of keeping tabs on our case and asking for quotes. And the jury was out all of 30 minutes. And I'll tell you, the best part of that trial was, just to give you a little bit more background of the mob involvement in New York City. About 6 months before that trial, there was a Gambino gangster who was the head of the Gambino family by the name of Vinny the Chin Gigante. And Vinny the Chin had this act to throw off the FBI where he would wander around the West Village in a bathrobe, muttering to himself because he knew he was being surveilled by the FBI, so they would think he was like crazy. And then they arrest him. He goes to jail. They monitor his phone calls, and really, it turns out he's not crazy. It was all an act. So when he was on trial, he put a psychiatrist on the stand as an expert to profess that Vinny the Chin was actually crazy. It was the same and it was before the same judge, Judge Leo Glasser in the Eastern District, who tried Vinny the Chin and sent him to jail 6 months earlier. So the same expert is now going to come testify against my doctor to say, on behalf of the drug mule, to say that she was wrong, that Mr. Kanye should not have been declared incompetent. So Dr. Portnow, psychiatry is kind of subjective, right? Like, two psychiatrists can examine the same patient and come to different conclusions. It's not like taking a blood pressure. There's a lot of opinion in this. He said, sure. I said, all right. So when you would examine a patient and another psychiatrist examines a patient and you have differing opinions, are you always right? Are you always the one that's right? He's like, well, I like to think blah, blah, blah. I said, weren't you in the same seat 6 months ago in front of this judge? And you said Vinny the Chin Gigante was crazy. And you were wrong then. Judge Glasser, I've never seen his eyes get so big. He didn't recognize the guy at the time, but he loved it. And he said, I let the record reflect. Vinny the Chin, like the record, they didn't know what they were talking about. He was very proud of having sent Vinny the Chin to prison, where I think he died several years later. So I got a taste for like standing up and having fun in the courtroom. And yes, of course, the press, the New York Post wrote some, they love these crazy cases. They like to dramatize it, or there's some drama involved in a case like that. But it was really just a judgment call by a psychiatrist that I had to defend that was very justifiable and appropriate at the time. So the lesson there was just like, pick up a case and try it. Like, right? Worst you can do is lose. And there's not a trial lawyer out there that hasn't lost a case, so you can't be afraid to give it a shot.
That's
So
great.
it was a sexy case, I guess, for the press, and that's why the New York Law Journal picked it up as a top 10 defense verdict, probably because of only how ridiculous it was. It was not me against, a class action of people who were actually maimed or killed or harmed in some way by a responsible party.
That's a fantastic anecdote. I think one of the best I've heard. Just all the connections there. That's great.
Yeah, it was fun. It was fun.
Generalizing the last part of what you just said there, right? I mean, you don't just litigate, right? I mean, you're a trial lawyer, so you're known for trying many cases to verdict, and maybe you win some, you don't win others. And in a world where the vast majority of cases, settle, what in your opinion and in your personal experience is the mindset of a true trial lawyer that distinguishes them from maybe a litigator who's willing to settle? What is it about the gravity of that trial that, as your bio puts it, that actually continues to draw you into the courtroom?
It's interesting. I remember back when I started out, and you'd go cover conferences for the partner, a pretrial conference, and the judges who oversee those parts, like, their biggest threat, if they wanted to make younger lawyers shake in their shoes and start panicking and call the client for more settlement money, they would threaten to make you go pick a jury. That was like their big lever to pull. And now, and I remember at the time, and every lawyer's been there, that's scary. Oh my God, I can't go pick a jury. The partner's going to kill me. And now you start trying maybe small cases. And at that first firm, like, we would try small claims cases over $700 over a taxi cab accident. But you get to go cross-examine a witness in front of a judge or an arbitrator or whomever. And you kind of work your way up from there. You second seat stuff, or you take on some small stuff. And that's why, DAs get great experience, because they're just kind of thrown into it. In civil practice, it takes a little bit more time to kind of work up to trying your own cases. But you get over that hurdle and you realize it's not, quite frankly, that big a deal in the long run. I mean, it is very stressful. It's a lot of work. The preparation for it, I think, is worse than actually trying the case, because you've got to get your mind around every last detail before the trial. And then once you're on trial, all you need to know is, what am I doing tomorrow? What am I asking tomorrow's witness? Like, you can just focus it, and it actually plays out slowly, kind of in slow motion, I always find. So you have time to think. But getting over that hurdle, and when a judge says, I'm going to make you pick, and you say, all right, that's when the plaintiff panics. If they know that you're going to take a verdict, like, and once you're known to be one of those attorneys that, if you don't settle the case with me, I'll try the case. I don't care. I said this to a lawyer yesterday. If he's not going to be reasonable, we'll just try the case. As long as your client, and for me, that's usually an insurance company, as long as they know the risks, and if they have a case valued up to X and the plaintiff's lawyer is at 2 or 3X and doesn't want to get reasonable, or you have a doctor who has to consent to a settlement and they refuse to consent, you have to go try the case. So, as they say, you put on your helmet and go. That's it. One step at a time, one day at a time. You prepare your witnesses, you prepare your experts, you read all the records, you read every deposition backwards and forwards 17 times, and you go. That's it. I had a case over the summer where the demand started out at $15 million. It went to 12 and then 9, to a bottom line of, we're not taking less than 4 or 5. And we tried the case to a verdict, and then while the jury was out, we reached a settlement where I paid 2. Okay. You have to, sometimes the trial, this is a Jesse Graham talk, sometimes the trial is just part of the negotiation.
Yeah.
You have to be able to play the entire process out to its end to get the best result and represent your client the best you can.
That's great. Yeah, I mean, it's in negotiation, a poker game, because you're essentially calling, the other side's bluff sometimes, right? I mean,
It is an absolute combination of a poker game, a chess match, and a gunfight, and a game of chicken, and a little bit of theater all thrown into one, right? It's all of that. It's a little bit more of some than the other, depending on where you're at in any given part of a trial, but it's all of that.
That's great. You mentioned chess match, Eric. So, one of the things I've been researching is that plaintiffs' attorneys recently have been developing, quite a bit of powerful, like, psychological strategies in recent years to drive large verdicts. And so, being on the other side as a top tier defense attorney, how do you counter those?
Yeah, I think what you're referring to is a concept that they call anchoring, and what that is at the end of a trial, plaintiffs' lawyers are allowed to ask a jury for a certain amount of money. They don't have to, but they can. And very often, look, cases that go to trial very often are close calls. It could go one way or the other. And a plaintiff's lawyer has to convince, at least in New York, 5 out of 6 jurors to side with them on every question, including an amount of damages to be awarded. And so, look, I've never served on a jury. I'm dying to, and most lawyers don't get to that point. So we're not flies on the wall. We don't know exactly what goes on in a jury room, but I think it's safe to assume there's some horse trading that goes on, and there's some negotiating that goes on. And the theory being, well, some jurors may not want to fine for the plaintiff, and then in exchange for, all right, we'll fine for the plaintiff, and then there's a deal to be made on the amount of damages. So maybe if they say we're only going to give them half of what they wanted, or what have you, if the plaintiffs start at a high enough number, an absurd number, one that they know would never, $20-30 million, they start the jury. And it plays into what's called the Reptile theory, which is they get their defenses up and they try to, although they can't use certain words and phrases during summation, they try to do whatever they can to get a juror to identify with the plaintiff and trigger like a fight or flight reaction to trigger a protective response, which is to provide for them. And so the combination of this Reptile theory and this anchoring theory is something that we on the defense bar are dealing with all the time. There's starting to be some case law where the courts have tried to put some limits on it, about triggering Reptile responses. And look, and there's certain things, and what makes it a little bit more difficult is during a trial, the defense gives a summation first. So you don't know what the plaintiff's going to say. Is he going to ask for a number, or isn't he, or she? And if they do, what's that number going to be? What I've done in the past, and maybe it was objectionable or not, I've said there's no pot of gold under the courthouse. There's no magical source where all this money comes from. And this isn't monopoly money. This is real dollars. And I remember I did this against a lawyer where I had a med mal trial where the case had already had one defendant settle out for $1 million. So if anyone lost for less than $1 million, we weren't paying anything, or $1.25 million. And it was against a very experienced plaintiff's trial lawyer in Queens. And I said, when he starts throwing out crazy numbers, think about the numbers and think about how much difference a certain amount of money makes in your life. Let's just say somebody walked up to you on the street and offered you, here's $10,000 in cash. Here's $50,000. Here's $100. Here's $300 or $400 or $500,000 in cash. Imagine if they walked up to you and said, here's $1 million in cash. That is extraordinarily life-changing. And when plaintiffs' lawyers start throwing around money like it's monopoly money, think about what reality is when it comes to that money. And he went bonkers and asked the jury for $8 million. And there was a defense verdict because the only one who was responsible was the guy who had already settled. But he almost jumped out of his shoes asking for $8 million and thought that I had basically told the plaintiffs, the jury, to award $1 million, which I wasn't. I was just trying to get them to wrap their minds around, like, what do these dollars really mean? And that was probably 20 years ago. And $1 million is still a lot of money. And these plaintiffs' lawyers ask for these amounts of money as if there's some magical pot of gold somewhere, and there's just not, unless they, you're in pharmaceutical litigation or some other big class action stuff. We're dealing with insurance policies usually, and that never gets known to a jury. That's the one where you can curse all day long in a courtroom, you just can't say insurance, because that's the I word. You can't say it unless the case is about insurance. But for the most part, jurors are blind to the existence of insurance, so you have to make it about real money, because it generally is.
Makes a lot of sense. Eric, you mentioned a little bit about some of the toxic torts that you handle, and specifically with pharmaceuticals. Can you talk a little bit about the work that you do in that space in addition to the med-mal?
Yeah, I don't really do pharmaceutical defense work. There's others in my firm that's a very, very carved out niche, and it requires a lot of specialized knowledge of the FDA and things like that. But throughout my career, it's kind of dovetailed off of the general liability work. I'm representing landowners, so I've gotten involved in, at the time, there was a lot of litigation 20 years ago on mold, toxic mold. And I've done a lot of cases about lead paint. And the concepts always come down to medical injuries, medical causation, scientific analysis. Does A cause B? To what extent? What are the other causes? So it's a similar analysis in terms of, analyzing the medicine, which is why, the med-mal lawyers, not myself, not just me, but anyone around who does med-mal defense, we're usually pretty good at branching off into other kind of injury defenses where the medicine is kind of the central point of the whole thing. So it helps.
That makes a lot of sense. Yeah. Coming back to the med-mal side of things, and looking at the evolution of technology, specifically medical technology, right? And so, what is your view on how the evolution of medical technology, EMRs, robotic surgery, AI-driven diagnostics, all of that, how has that changed the landscape of medical malpractice defense? Has it made it easier, more difficult, both? Why?
In the first instance, I'd say the biggest difference, and this probably goes back now 10, 12 years, is the introduction of EMR, electronic medical records. Everybody hates them, except the insurance companies and anyone else who's trying to mine data out of them. When doctors could just hand scribble a note, and then their deposition would basically just be reading their notes because no one else could read their handwriting. That was like the good old days. What happens with EMR now is it's done with pull down menus when doctors input things. And they just have to pick from a list of options generally, because it's software. And things get entered once, and you hope they're right and accurate, and then they get repopulated for every subsequent visit. And very often it makes it look like it doesn't make sense, because a sentence that'll say, onset of chest pain 2 hours ago, that's at the first visit. And then at the third visit, it still says onset of chest pain 2 hours ago. Well, it's like, no, that was 3 months ago. So it's efficient, I suppose, in some respects in the healthcare practice. But if you ask any old-time doctor, they'd probably rather go back to scribbling some notes in handwriting no one can decipher. So just having to explain and have everyone understand, because you have plaintiffs' lawyers that would love to use those records as the gospel and the Bible of this patient's or plaintiff's treatment. And just there's errors that happen that's just implicit in the way the software runs that creates inaccuracies that, yes, you can explain it. And sometimes it's dated and it's just, put below the next entry, but it just doesn't look like a real accurate record just because of the way the system works. In terms of AI, It's just, I haven't seen malpractice cases yet that are involving AI, but I know that AI is creeping into medicine, probably with radiology first. And until someone shows otherwise, the evidence right now is that, radiology, some studies are better read by AI than by a radiologist. So I'm sure a radiologist could talk to you at length about how they're better at reading a mammogram than AI. And if I'm waiting to see, and I have not yet seen the first case where AI missed a suspicious mass or a suspicious lesion in her breast, and the radiologist caught it. And in which case, like, are you going to sue the AI company that provided it? Probably, but that hasn't happened yet. But to be honest with you, the biggest impact on the practice from technology in the last, say, 5 years has probably been, the electronic filing of things. There's no more paper anymore, almost no more paper. Everything with the courts is electronic. It can be accessed from any time and anywhere. It's actually great because you can file something at 11:59. You don't have to mail anything. You don't need someone to put it together and get it out the door for you. You can serve everybody equally. You can research the entire case on the court website. So that's great. Part B is, and the other big difference is the hangover from COVID, which is the utilization of remote everything. Remote conferences, remote mediations, remote depositions. And this was started out of necessity during COVID. And it is the only thing that allowed us to keep practicing. Like, we would have been twiddling our thumbs for a couple of years probably. Zoom saved the practice that we were all able to do, team meetings internally like everybody else, but also depositions. But it's not an ideal way to depose a witness. It's not an ideal way to get a record. It's not an ideal way to interact with your opposing counsel. So there are definite drawbacks to doing it, and it's only stuck around out of convenience. Some would say laziness. I like to, if I'm going to depose certain plaintiffs who are, I think would be, if I want to size them up and see if they're really as injured as they say, or certain cases it doesn't really have that much of an impact. Like if someone has a bladder cancer case, I know how they're doing, right? But if it's a general liability case or another kind of malpractice case, and I want to size somebody up, whether I want to evaluate their ability to move or their mannerisms or get in their face more because I think they're lying, I press to do those in person. And some of the courts are still reluctant to order it, and the plaintiffs' lawyers avoid it like crazy. They don't want to have to produce their person in person because they know, police would never interrogate a witness over a Zoom call. It's not you're not going to get to you're not as effective through a TV, I don't think, as you are face to face across the table. So when it comes to a compliance conference or mediation with people, it's very useful. Although I can tell you a lot of the best legal work gets done in the hallways. BSing with your opponent or your co-defendants, whispering, to each other during a deposition, the intangible stuff. And we're finally getting back to that. I was in court this morning. We appeared before a judge, but the real conversation happened out in the hallway as I and my adversary are walking out of the building. We shouldn't lose that, because that's kind of where the important stuff happens. What are you really looking for? What's your guy need? That's where that's the courtroom stuff. That's when the real work gets done. And when you just sign off a Zoom, you don't have that opportunity. You have to go out of your way to have it. So I think the remote aspect of it, and I think look, if you have a case that's, say, I'm in Manhattan. If there's a Suffolk County case and there's 8 defendants in it, it's more convenient for everybody to just zoom in and do the deposition that way. And we're all pretty much fine with it. But when it's important, we need to get away from that, I think. But it's been a big change. It's been great for the clients. There's no travel being billed, so they save a couple hours or something like that on a deposition or a court appearance when it's just clicking into a meeting.
Makes sense.
Yeah.
Yeah, that is interesting. I mean, there's pros and cons, and I think you laid them out very well, Eric, for our audience. So thank you for sharing that. Looking ahead from with the experience and expertise that you have as a defense attorney, what emerging risks should businesses and insurers be preparing to defend against? What sort of trends are you seeing in terms of either on the med mal side or the class action side that you see sort of coming down the pike at a high level?
It's very hard to say. Like everyone else, everybody's curious to see where AI takes us. It's going to probably impact everybody in some way. Whether it's our clients, we know it's going to filter into the medical practice. It's already filtering into the legal practice. Although, I have another thought on that. What you've seen over the last 10 or 15 years in medicine anyway is consolidation and the influx and kind of takeover by private equity and the consolidation of independent medical practices, whether they were 1 doctor, 5 doctors, or 20, being absorbed into bigger groups and then bigger hospitals. And then, whether in the New York area, it's the Mount Sinai group, or it's the Langone NYU group, or the Columbia group, and now Optum is under United Healthcare. There's everything gets consolidated, and the doctors become employees of much bigger. They become corporate employees. So they're all working harder than they probably ever have had to work, and they're not the rugged individual doctors anymore. Quite frankly, I think the quality of care suffers as a result when it's managed at the corporate level and not the medical level. And people may disagree, but I think you see it everywhere where when profits are the driving force and cost cutting are the driving forces in the provision of care, something's got to give. So there are bare standards, and the doctors are being asked probably to do. Doctors have no room for error. I mean, they're one of the doctors. When a lawyer makes a mistake, we can probably fix it with a phone call or a motion to amend or whatever the case may be. It's rare that a legal mistake isn't fixable. That's not the case for doctors. They're living in a biological construct. We're living in a man-made paper and pencil construct. So biology doesn't wait. You can't move to amend a medication, right? So they're on the line every day making decisions, hundreds of them a day, that can have important impacts on everybody, their patients. And they're being asked to be held to the same standard of essential perfection, because if anything goes wrong, someone will find a way to blame it on the doctor. Any suboptimal result seemingly results in a lawsuit. So I think it's going to get harder and harder for the doctors to remain as perfect as the plaintiff's bar expects them to be, under the pressures of the way medicine is managed right now. That's kind of the 30,000 foot view that I see.
Yeah, that's a great insight. Thank you for sharing that, Eric. This has been a fantastic conversation. Deeply insightful, and I really appreciate it. Just a couple of quick questions to sort of wrap us up here.
Sure.
The first one is what advice would you give to a young associate who is looking to be a successful trial lawyer, specifically on the defense side? Not everybody's going to have the very unique origin story that you had. So for somebody who's sort of just out of law school, looking at today's sort of social, legal, technological, societal, landscape, what advice would you give them? What skills should they develop? What should they be doing?
Yeah, I think there's a lot of litigators, there's a lot of insurance defense lawyers, of which I think only a small percentage actually try cases. If you really want to get to where, maximize your potential in the business, I think you really need to be one of those lawyers that try cases. If you want to be a lawyer who you can go to potential clients, insurance companies or medical practice and say, I'd like to be your lawyer. There's no reason they should hire someone who can only take that case up until the last pretrial conference, and then you've got to give it to another lawyer who can go try the case. You've got to be able to take it from start to finish and be responsible for it the entire way. So make it clear to your supervising people, senior associates or partners, that you want to try cases. Look for any and every opportunity to either try a small claims case or second seat somebody or get involved deeply in the trial prep so you know what the process looks like. You be one of those people that just drop your fear. Understand that when you're on trial, it will be all consuming. And for some people, that's just not what they want to do. When you're not on trial, you can manage the job. It's not crazy. But understand, when you're on trial, you're up till midnight working on the case, and you're not even responding to emails. It's like, all right, I will deal with anything and everything else when I'm done with this case. And when you have small kids, as I did, it's hard. And hopefully you have a spouse who will be like, all right, I understand. But it's not easy, but it's rewarding, and just to get as much into the trial part of the business as you can if you want to keep going that direction.
That's great.
If it's small, try cases that are $500 for over a taxi cab fender bender. Start with that. Make an argument.
That's great advice, because I would imagine that at a high level, the processes that you follow are essentially the same, and then obviously there's nuance and depth as you get.
If it's a $100,000 case or a $10 million case, you're still doing the same thing. That's it. Yep.
Amazing. Final question for you, Eric. Is there a question that I should have asked you but I didn't? No, I think we covered it. I mean, I like it. Like I've had plaintiffs lawyers ask me, like, why don't you do plaintiffs work? I'm like, well, it's not in my DNA to be a complainer. I'm more of a I defend the accused. And as you saw on the website, I got into this in some small inspiration from To Kill a Mockingbird. It's someone who stands up for somebody else who can't stand up for themselves. And I'm sure the plaintiffs' lawyers, if you ask them many of the same questions, would feel the same way about what they do. They're standing up for someone who's been egregiously wronged by some other party. And look, our jobs, anyone can make a claim, anyone can blame somebody else, and it's our job to really figure out what happened and not just blame somebody because something went wrong. So. Fantastic. Well, Eric, this has been an immensely thought-provoking and wonderful conversation. I really appreciate it, and I'm sure our audience will as well. So thank you so much for your time and insights today.
Thank you for all the questions. I appreciate that as well. I can be reached at eric.strober@rivkin.com. I'm at Rivkin Radler in New York.
Perfect. Thanks, Eric.
Yeah. Bye-bye.
Yeah, bye-bye.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.